the matter of Loreley Financing Limited and Credit Suisse Securities Limited and others.
May it please your Lordship,
Yes, good morning, Mr. Lord.
in this appeal I appear for the appellant, Loreley 30, with my own friend Mr. Hobson. The respondent, Credit Suisse, is represented by my own friends Miss Oppenheimer, King's Counsel, and Mr. Scher.
Yes.
As your Lordship knows, this is an appeal from the order of Mr. Justice Robin Knowles, dated 10th of June 2022, made with permission of the learned judge. And the order is to be found behind tab 4 of the core bundle, where you will see that the learned judge acceded in paragraph 1 of page 67 to the application by the respondent, Credit Suisse, for this material or information, putting the matter neutrally for now, to be disclosed to it.
Sorry, could you just give me the page number?
Certainly, my Lord. It's in core bundle behind divider 4, page 67.
Just the electronic numbers enough for me, thank you. Yeah. And the order is the individuals who have been authorised to give instructions to RPC on behalf of the claimant are not subject to
Legal professional privilege.
RPP.
The learned judge's reasoning is set out in his judgment behind divider 5 of the core bundle, starting at page 70 of the bundle.
Again, if we can just have paragraph numbers for the judgment, please.
And the way in which this matter and the appeal arise are set out succinctly by the judge in his judgment, starting at paragraph 3 through to paragraph 10, starting at page 71. And I invite your Lordship to read those paragraphs because it sets the matter out.
So which paragraphs?
3 to 10.
3 to 10 of?
The judgment.
Okay. 3 to 10 of the judgment gives the litigation history.
Yes, I explained that that's how the matter
We don't
arrived.
need to read it again.
No, I wasn't sure how much I had to.
Okay.
I had to
You
open.
certainly don't have to,
I had to
get into all that.
open the appeal.
That's lovely.
So that's the way in which this issue and the matter arises, and I can take it from that last point from my Lord that there's no need for me to take you to the underlying material, the Part 18 reply, and the other material. I'll move straight to my submissions if that would find favour.
Absolutely.
My Lord, in the usual way, I won't rehearse the contents of my written skeleton argument, but I rely upon the contents, and I'll seek to amplify, augment, and deal with the respondents' points, such as they call for oral submission. My oral submissions, my
Perhaps
Lord,
the judge's points would be a good idea as well.
yes, I will go to the judge's points. I know that's a screwdriver, and I'll be wielding it very soon, my Lord. In terms of the structure of my oral submissions, I was going to set out my submissions in a nutshell, which would involve very, very, very succinctly explaining why the judge went wrong, setting out what I hope to be some common ground or straightforward legal principles shortly, given this court's familiarity with the underlying jurisprudence, and then I will deal with why we say with respect that the judge went wrong, which will necessitate my explaining the right approach and the right result, those being two sides of the same coin. So I will go through the judgment, and I will try to show where the judge, we say with respect, went wrong, and to show why, if he hadn't taken a wrong turn, he'd have ended up at the place that we invite your Lordship to arrive at. My Lord, our submissions in a nutshell are as follows. Litigation privilege and legal advice privilege may coexist. The claim in issue on this appeal is one for litigation privilege over the following material, which Credit Suisse seek disclosure of. The names of the individuals who are or have been authorised to give instructions to RPC in relation to the litigation. We submit that there can be no issue here, but that the identity of these individuals are of persons giving litigation instructions, quote unquote, on behalf of a party to such litigation, to their litigation solicitors. And that's a very important piece of context. We also say there can be no question but that such litigation instructions are themselves protected by privilege, and that we say litigation privilege plainly applies. The instructions, quote unquote, must be, we submit, privileged communications, quote unquote. And what the respondent seeks in this application, as acceded to by the early judge, is the identity of the communicator of such privileged communications. And our primary submission, which we made to the judge, is that the identity of the communicator is part of the communication and therefore falls to be protected as such from disclosure via litigation privilege. See the analogous reasoning for witness identities and proofs of potential witnesses, in particular the reasoning of the Vice-Chancellor Sir Andrew Mollett in the China National Petroleum case, to which I will return later. Further, or alternatively, if, which we say you cannot, you can extract the communicator's identity from an otherwise privileged communication or privileged part thereof, such identity, we say, is clearly and manifestly connected with that channel of communication so as to attract litigation privilege.
Sorry, can you say that again? Just sort of a bit convoluted. Just what was that submission?
Well, it was really that if it ends so far as one can extract from the communication.
Just ditch some of the lawyer's garbage, can you? If and in so far, if is good enough. If what? If you can take the identity of the communicator.
If you can, you have to speak up as well. Then. If it's possible to extract the identity of the communicator from the communication.
Yes.
And our primary submission is you cannot do that.
Yes.
But if in fact you do travel to that second point, we say that the identity of that communicator is clearly and manifestly connected with the channel of communication with which we're concerned, which is a privileged channel. And therefore, it attracts...
so what? I mean, where does that... The identity is connected with the channel of communication, obviously. But, I mean, what's the legal submission?
Well, I'll show you the reasoning of Justice Tier in the Ablyazov case, and the reasoning of the High Court in the SRJ case, which we say are analogous. And that is not... And that the identity of the communicator in this case is not simply routine or background information in what is an adversarial setting. And one can analyse that further way of putting the point in a number of ways. It may be no more than a means of ascertaining the true scope of the communications with which we are concerned here. In other words, as an interpretative aid when applying the orthodox test for litigation privilege. It could be viewed as a gloss on such test, or it could be viewed as supplying any additional requirement, quote unquote, if that is required. See the Ablyazov reasoning, to which I will come, in which Miss Justice Tier cites Lord Bingham in the Crown and Manchester Crown Court ex parte Rogers case, and the words "without more" that Lord Bingham inserted in that Manchester.
I thought this was a summary of your submissions. I mean, the sort of see this case and that case is not helpful to me. I've read your skeleton, which does that. I either need to go to that case and hear the argument. I thought you were giving us the headline points of your submission.
That is the headline.
I mean, this is the kind of thing we'd want to see in writing. I can't write all that down.
Well, can I then, in summary form, go to why the judge's approach is wrong? Again, in summary form, the judge applied, we say, not the single litigation privilege test, but two tests, or a two-stage approach, which was wrong.
Why?
Because there is a single test for litigation privilege.
Single test is?
Whether the communication came into being for the dominant purpose of obtaining advice, information or evidence in connection with litigation.
So you say that the communicator, if the communication is communicating something privileged, the communicator is always privileged from disclosure.
In a litigation privilege setting, yes.
Yes, no. And so if you were cross-examining and you said, I know you met your solicitor, Mr. Jones, I'm not asking you about what you said, who else was at the meeting, that would be ruled out in a normal commercial trial, would it?
Well, if what you're asking is who was giving instructions to the solicitor, then you couldn't ask that.
I've never been at a trial where the judge intervened to say you can't ask who's at the meeting if you're not asking what was said.
Well, the meeting we're positing is, for example, a meeting with counsel, a consultation. So on your lordship's point, what we're positing is there's a conference with counsel to which 3 client representatives go, and at the trial, the opposing counsel is entitled to interrogate who was at that privileged
conference. What if it's more complicated than that? It's not a conference with counsel, but it's a meeting in a public place where things happened and you have to disentangle the privileged part, which is terribly common.
Well, if you disentangle, if there is a non-privileged communication, then that isn't going to attract litigation privilege by definition.
But that's why it's so difficult, isn't it, to say that the identity of the communicator is always privileged, because life doesn't simply take place in counsel's chambers in a privileged environment where you might find that question would encounter difficulties. But, I mean, when you come along and say to me, I've got instructions, and I will say, who's got instructions? Who have you got instructions from? And you'll say, I've got instructions from X, and you'll say, I'm instructed to tell you why. And there's nothing privileged about who told you.
Well, I'm not sure whether that's correct. I'm not sure that the court can.
I mean, it's incredibly wide-ranging, your submission.
Well, it's not really about it. The question is where you are dealing with litigation instructions. So on this premise, what is being sought is not some meeting where business matters were discussed or some other part of the story, but you have to posit that is a privileged exchange.
No, but just forgive me. You are positing a test which applies to everything.
Well, what it would mean...
It applies to any occasion in which litigation privilege might be engaged for the communication. So it has to be as broad as I'm putting to you. That's why you're driven into that. Because if you didn't do it that way, you couldn't succeed. So that's why I'm putting examples to you that are surprising.
Well, if the communication is privileged, that's what we're dealing with. We say it's not surprising that the communicator, who we say is part of that communication, that is privileged. And if I'm wrong about that, it would mean this: that every attendance note in litigation of a conference with counsel or a trip to see your solicitors, the people who attended from the client, the fact of that meeting, and the people who attended would be a disclosable document, if relevant. And no one has ever suggested that you would have to disclose an attendance note of a conference with your lawyers in litigation. And that is the upshot of Mr. Justice Knowles' ruling. Because on your lordship's question, none of that is privileged. So you'd have to disclose attendance notes with the contents of what was said blocked out, but not the personnel who attended.
Well,
and more than that,
I was brought up, Mr. Lord, in a different environment where you had to put part 2 of your discovery list, where you had to say what privileged documents you were not disclosing and why. And in part 2, the formal position was you did have to say, I have an attendance note of a meeting with counsel attended by X, Y, and Z, but you didn't have to disclose the contents. And that was how discovery used to work. Now, of course, we've got disclosure and it's all much more laissez-faire. But that was the old days.
Well, I'm not sure, my lord. I can't speak. I'm afraid I can't speak for that practice. But certainly, the upshot is that attendance notes showing the occasion of a meeting, the date of it, and the client representatives there, and their lawyers, that on your lordship's example is not protected by litigation
Well,
privilege.
you have a look at the rules of the Supreme Court for 1999, and see how it describes what should go in the Part 2 of the list, and you will find that that was the old position.
Well, my lord, I certainly accept that you would describe. I certainly accept that you would refer to attendances upon counsel, attendances upon solicitors, and the like. But I don't accept that that involved you giving the names of all the people who attended that conference. Still less that the document would be disclosable, because on your lordship's example, the only privileged aspect are the words that were exchanged, and not the identity of the people who were there.
No, I didn't say you had to disclose the document redacted. I said you had to say what the document recorded and included, in many cases, who was there. But you're quite right, you didn't have to disclose the document.
But if your lordship is right,
If it was an obviously totally privileged occasion.
if your lordship is right in the question to me, and if Credit Suisse is right, then a party to litigation is entitled to interrogate that sort of privileged occasion. It may well not be relevant in many occasions, but if it is relevant, privilege is not going to come to the aid. And
But you say, Mr. Jones, did you have a meeting with counsel on the 14th of June? That is relevant to the question of limitation, because you were taking legal advice about this question is not an appropriate question in cross-examination.
What you can't ask is who did you authorise to give?
No, just answer my question, if you don't mind. Mr. Jones, you are a witness. Counsel for the other side. So, Mr. Jones, did you have a meeting with counsel on the 14th of June 2020? Because that is relevant for me to know whether you had certain knowledge. I'm not asking you what happened. Did you have a meeting with counsel?
We could ask that.
And you can't ask that question.
Well, you could ask that question.
Well, because
That doesn't betray. That doesn't betray the channel, the way in which instructions on the litigation. It doesn't betray the communicant of privileged instructions. And you wouldn't have to go on to that.
Of course it does.
While we're on disclosure, if you look at the current rules, with which no doubt you will be familiar, a party has to give a disclosure statement, CPR 31, and that has to be made by the party, or where the party is a company. The individual has to identify, the person making the statement has to be identified and explain why he is considered an appropriate person to make the statement. So the assumption is clearly that that is not privileged information. How does that sit with your submission?
Well, my lord, that's a different point with respect. That's the party having to explain and validate its disclosure process. It's not the same. It is not the same thing as requiring the party to disclose its communicator of privileged instructions. Those are different points, and disclosure does raise difficult questions, because as your question to me raises, there is a tension when giving disclosure statements that one has to explain some of the processes. One has to be careful not to waive privilege, and no one has ever suggested that privilege is waived in that way. But one has to be very careful to identify the particular searches and the like. But that's different. That is different from saying that instructions that are privileged, the communicator on behalf of the client, that identity is not protected, because one has to test it. One has to test it with some privileged instructions. One has to test it this way. You have privileged instructions to a solicitor or counsel from a client, let's say, and who is sending those instructions for litigation to the lawyers for litigation. That is not protected, and it is going to be relevant potentially, as in this case, with institutional and corporate clients, as to who is giving those instructions. Is it the CEO of the bank, or is it somebody much dare I say, of a more junior level? Is it in fact, are the instructions coming from the top banking people in Tokyo and New York, all around the world, to show just how important this case is? Or is it, or not? And the bank may have written back, to the other party to say, your claim for $100 million, let's take a hypothetical example. Your claim is entirely speculative, it has no merit, we're not going to spend any real time on it, and we'll fight it all the way. In other words, a huge raspberry is blown. And then you've had, well, that's, I'd like to know, please, who was giving the instructions? Oh, crikey, all these very important people. Well, that doesn't look as if the bank's not worried about this or taking it seriously. And what they've asked the forensic accountant to quantify loss. Well, that's very interesting. Well, I think we better press on here. Looks like we may be onto a good claim. And the key point is this: in an adversarial context, which litigation privilege arises in, it is a contest per Three Rivers number 6, Lord Carswell. And there is a cat and mouse, and there is a sensitivity to that. And just stopping there to see the ramifications if we're wrong, in every single case where you have a corporate client or an institutional client, insurer, bank, big company, any of those litigants in which there is a question as to their corporate knowledge, attribution, directing mind, control, the question of how that corporate litigant, who is authorising its instructions for that litigation, falls to be disclosed. Because, on Credit Suisse's case, that is potentially relevant to show knowledge, attribution, control. In other words, well, if Mr. X is running the litigation, per the instructions, we can start to make progress to say that he, in fact, was a relevant brain for knowledge. And that's an extraordinary opening up of litigation preparation. Extraordinary. Without any warrant. And the reason you don't find cases for that, in my respectful submission, is that it's without any warrant. No one has thought before, in a litigation context, where you know who the client is, because by definition, it's a party or potential party. No one has thought to go behind that, to burrow into the privileged instructions between solicitor and client, to say effectively whose name is on the client instructions, or names. It's an extraordinary abrogation of privilege, in my respectful submission. The law, I'm going to deal with the law quickly. This should be common ground. First, the fundamental importance of legal professional privilege to the rule of law. I anticipate that is well understood by this bench. But for your Lordship's note, there's a very helpful summary in the Jet 2 case, tab 29 of the authorities bundle, page 692, and the paragraphs of the judgment are 35 to 41. And I want just to take your Lordship to one part of that.
Which page in the electronic bundle?
692.
Sorry,
692.
692.
And in paragraphs 35 to 41, Justice Higginbottom set out some familiar authority in relation to privilege, explains that legal, that as originally formulated, the privilege covered only what's known as litigation privilege, explains that. And then it was expanded, in effect, to non-contentious exchanges, hence legal advice privilege. And he explains all the background. Paragraph 38, he cites the well-known passage from Lord Taylor's speech in Derby Magistrates and House of Lords that legal professional privilege is much more than ordinary rule of evidence, limited in its application to the facts of a particular case. It is a fundamental condition on which the administration of justice as a whole rests. And then over the page, paragraph 40, Lord Hoffman and Lord Grenfell, it's a fundamental human right. And then Lord Scott, paragraph 34 of Three Rivers number 6, where in part of that long citation, he talks about its importance within the controlling framework built upon a belief in the rule of law. So as I'm sure is common ground, legal professional privilege, including litigation privilege, is a fundamental right, and it is fundamental to the administration of justice in English law and to our rule of law. Which is why we say, with respect, one has to be very, very wary of creating any inroads or encroachments into that protection. If I move, please, to the rationale, scope and test for litigation privilege, conveniently summarised in the SFO and ENRC case, in which my Lord the Master of Rolls gave the judgment for the Court of Appeal. That's behind tab 27 of the authorities bundle, and the number starts at page 600. But relevantly for this submission, one goes to page 627 to pick up paragraphs 64 to 66. Where there is a helpful summary of the law. And in paragraph 66 it was said by my Lord the Master of Rolls in this case that the above citations carry authoritative weight and there is no need to be re-examined and may be taken as accurate, and we proceed on the basis that that's correct and that does authoritatively set out.
Which bit of the citation do you say is critical to your submission? This is the Lord Carswell citation.
It is, my Lord. The critical bit really is put in paragraph 64, but it's worth having 64 and 65 because one...
Right.
64 is the, as Lordship rightly observes, is the oft-quoted formulation for litigation privilege. But there is a relevant section in paragraph 65, page 628, at the foot of that page, beginning, I agree with the view expressed by Mr. Justice Coleman in Nederlandse Reassurance Group. But the statement of the law in Ballabel does not disturb or modify the principle affirmed in Minter and Priest. All communications between a solicitor and his client relating to a transaction in which the solicitor has been instructed for the purpose of obtaining legal advice will be privileged, notwithstanding they do not contain advice on matters of law or construction, provided that they are directly related to the performance by the solicitor of his professional duty as legal advisor of his client. So we say that that is important and correct. So protected communications in a litigation setting between lawyer and client will not simply be advice on the law or the merits, or simply be, well, we could get that witness, or that's the evidence we need. It goes beyond that to the conduct of that litigation, properly so understood. Because there will be a continuum of advice and help and assistance. There will be some pure legal advice. There will be some litigation strategy, some settlement discussion, be all sorts of things that are quintessentially protected by litigation privilege between litigant and his litigation lawyer. There is, if we go please to the WH Holding case in the Court of Appeal, that's behind divided, at tab 28 of the bundle, at page 654. Electronic reference, and picking up please just at paragraph 10 at page 658. And for your Lordship's note, just in terms of helpful distillation or collation really of relevant learning on litigation privilege, paragraph 10 sets out that it's a single privilege, legal professional privilege, but it has two separate limbs, litigation privilege and legal advice privilege, and they are not necessarily coterminous. And they refer to the court pointing, as the court pointed out in ENRC, at 63, that's the SFO case, they have different characteristics. And that's important, and we say that is correct, and needs to be borne in mind on this appeal. And then your Lordship will see paragraph 11, Lord Carswell summary of paragraph 102 was there cited. And then we go please to paragraph 13, to the Anderson and Bank of British Columbia citation. And that's really making the point, with respect, that it's not just information that ends up being used in litigation. In other words, it's not simply exchanges between lawyer and client in litigation that are going to be on the face of the case, so evidence or whatever, but it goes to, if you like, advice on the merits and so on. So it's behind the scenes advice as well. And then in paragraph 16, final reference to this case, is a reference to Wheeler and Marchant and Sir George Jessel, which does probably no more, I think, than set out the basis for the formulation by Lord Carswell in Three Rivers. Can I just give your Lordship two very small references to Three Rivers number 6 that are not in those summaries, just for completeness. And that Three Rivers number 6 in the House of Lords is behind divider 16 of the First Authorities bundle. Electronic reference 321, starting, I simply two paragraphs I need to take your Lordship to. First is at page 365, paragraph 52.
Paragraph.
Sorry, my Lord.
Paragraph
52, my Lord.
52.
This is in the
Just for your
speech of Lord Roger.
So just for your
Sorry, my Lord.
information, paragraph 52
Yeah.
is on electronic page 369. So I think you've been 5 pages
Well,
out.
I do apologise, my Lord.
Yes. Well, just a note for your solicitors, very important to have the electronic pages the same as the paper ones.
Well, I'm very sorry, my Lord. I apologise.
Right, it's not your
And
fault. I should now know that it's 4 or 5 pages on.
So,
Don't try and give me different references.
shall I give you different references?
No, you give me the right
That's going
ones
to test
you've
my
got in your
arithmetic as well
notes
as my
and I'll add 4.
jurisprudence. Yes, my Lord. So, paragraph 52. This is
Yeah.
in the speech of Lord Roger, and it's important with respect on this appeal because it explains this. Litigation privilege relates to communications at the stage when litigation is pending or in contemplation. It is based on the idea that legal proceedings take the form of a contest in which each of the opposing parties assembles his own body of evidence and uses it to try to defeat the other, with the judge or jury determining the winner. In such a system, each party should be free to prepare his case as fully as possible without the risk that his opponent will be able to recover the material generated by his preparations. In the words of Justice Jackson in Hickman and Taylor, discovery was hardly intended to enable a learned profession to perform its functions either without wits or with wits borrowed from the adversary. And the point to get from that is that litigation privilege has that philosophical or principle basis as part of our rule of law.
But if you look at that dictum, it's quite interesting, isn't it? Litigation is a contest. But why are the parties to the contest? Why are the combatants privileged from disclosure? Surely you need to know who your enemy is.
Well, that's true.
In the digital environment, we're now considering whether you can have contests between parties who are not identified. And that's quite a big issue because as we know, in digital assets, sometimes parties are anonymous. But in the world we're talking about at the moment, you generally know who you're fighting in litigation.
Yes, but there is a material difference between knowing who your adversary is, who the party is you're facing. That's one question.
Well, knowing who the sort of the A124 Trust Company Limited of BVI, that's enough, is it?
Well, there's a difference with respect between knowing the party to a dispute.
Well, that's A124 Trust
Yes,
Company
yes,
of BVI. That's enough to know? You don't need to know who the real people are.
Well, that's with respect. That's not the question in point here.
It is the question.
It's not. Well, my lord.
Let's say the case is A124 Trust Company of BVI versus B268 Trust Company of Bermuda, right? Surely paragraph 52 envisages that at least you will know that Mr. Smith runs the plaintiff, claimant, and Mr. Jones runs the defendant and gives instructions on behalf of them.
Oh, well, my lord, pausing there, there is a difference between a step change between the question of who runs a trust company and who is giving instructions for the litigation on behalf of that company. It's an obvious difference. I accept that the first question, if there's an issue of control or piercing the veil or of course I accept that that is going to be fair game, but it doesn't bring you into accessing which people are giving privileged instructions. That you can't do. That is protected. And we say that there's a bright line, an obvious line between those two. And with respect, that I just fell into this mistake. He was drawn into the line of legal advice privilege cases, which really say, well, what's in the name of a client? You've got to have a client to found legal advice privilege. So there's nothing to protect there. That's it. That I'm summarising many of the cases in legal advice privilege. So the bank submits, and the danger with that is that you forget that litigation privilege is in the adversarial context. It's about a contest, and you don't look at the question of a privileged communication is not just the words that are used, but it's the occasion and the people who are present. That is all part of the communication, quote unquote, or the document, quote unquote. Take my attendance note. And that is protected entirely conventionally by litigation privilege. That doesn't stop anybody from cross-examining a trust company in the Bahamas about all the holding companies and directors and who decides to do this and who files the accounts and who's a real beneficiary and who's the trust and so on, and ask that till the cows come home. What you can't do is to burrow into litigation instructions, to have a sort of sneak peek behind the curtain and say, whoa, what if that's Mr. X doing that? Perhaps he's the person who really runs all this. That's what I'm going to say to the court. That's what you can't do because you have gone into the privileged world. And that's what this case is all about.
All you've gone into is the fact that when the solicitor says to the court, or the barrister says to the court, I am instructed that this case is being, this part of the case is being dropped, that the person who gave that instruction was Mr. Jones.
But the court wouldn't normally ask who it was, which person within
It would if there was doubt as to whether he had authority.
Well, that would be privilege. Why would it? The submission will be made. This part of the case has been dropped. I accept that if something turns, as far as the court is concerned, on the identity of the person concerned, involved in a privileged matter, the court, I can see a situation where a party may feel that it has to provide that piece of information, but that would be waiving the privilege. And if in fact without that waiver, various inferences could be drawn with which that party did not want to live, then it may have to go down that route.
Is that a logical distinction?
Sorry? Pardon?
What you've just said, is that really a logical distinction?
It is a logical distinction. So it's a logical distinction between,
if the
courts often would like, the questions are often asked to which the court would like to know the answer, and the answer is, well, it's privileged. And if without waiving the privilege on what is admissible otherwise, there is inferences can be drawn and findings can be made on that material, then the party claiming privilege is stuck with that. But it's different from saying, because the matter seems relevant to the court, the party effectively has to waive privilege to complete the picture.
Solicitors make witness statements or swear affidavits every day in which they have to state the source of their information and belief, and that will derive from the person who gives them instructions about whatever it is they're swearing to. But nobody ever thinks that that is a waiver of privilege.
But they've chosen, my lord. The party has chosen. The party in question has effectively elected and consented. To that extent,
Well, they may have no choice. It may be they're resisting an application and they have to depose to something in order to do so.
but that is a different question from whether it's a different question from whether a privileged communication, an instruction for litigation, the giver of that on behalf of the client that does not fall to be treated as part of that communication. That is the simple point.
So
That's
take an order 14, as I used to call them, part 24, summary judgment case, where the solicitor, the claimant puts in a statement, the defendant solicitor puts in a statement and says, I'm instructed by Trust Company 124 of Liberia
Yes.
that the facts in this statement are true.
Yes.
You say that it would not be open to the other side to say who is Trust Company 124 of Liberia, who has told you the facts in your statement are true, because if you don't tell us, we're not going to necessarily believe it, and the answer to that is it's privileged information.
Wait,
You don't have to tell
no,
us.
that's not right, my lord. If you're putting in evidence in a case through a solicitor or
Yeah,
otherwise,
but it's a privileged communication when the person on behalf of Trust Company 124 said that it was true. That's a privileged communication.
you have to identify in the witness evidence the basis, the evidential basis. So that is not the same, with the greatest respect, that is not the question issue. The evidential basis for a piece of evidence or submission or an answer to the court is not the same thing, as the privileged status of a privileged communication, namely instructions. Those are different points. Those are logically and juridically different questions. The fact that the party may say, Mr. X, my sister, the director tells him 10 different things, and he says, I'm instructed by Mr. that the basis for this witness statement is the instructions or the evidence or the information from Mr. X in Barbados. He has to say that to give the matter some evidential body. What cannot then happen is that the whole question of the instructions at large are opened up to say, well, were those the only instructions that Mr. X gave you, solicitor? Were other people involved? Was he the only person who knew about this? You can't ask those sort of questions. Those go into privileged matters. And the fact that on interlocutory disclosure matters, there is this sort of basing of your evidence requirement doesn't begin to require you to open up privilege. It's not the same thing. Just I'm afraid with great respect, it is a non sequitur to opening up the privilege. The other, I think I was in Three Rivers number 6. If I could go, please, just paragraph 85, page 378, my pages, maybe 382. This is Lord Carswell, setting out the object of litigation privilege. He says this was described in the classic statement of Sir George Jessel, Master Rolls and Anderson, and Bank of British Columbia. And it's read the last 4 lines. It's the whole quote, but relevantly for this submission, I'll take it shortly. It ends thus. The man should have a clean breast of it, and that the communications he so makes to him should be kept secret, unless with his consent, for it is his privilege, and not the privilege of the confidential agent, that he should be able to conduct properly his litigation. That is the meaning of the rule. So that is what we're talking about here. We're talking about being able to make a clean breast of things and talk in a continuum, lawyer to litigant, and we say, classically, that is kept secret. And when we use the phrase zone of privacy, it's only another way of referring to this classic requirement of keeping something secret. We don't suggest that the zone of privacy is its own touchstone. It simply is a shorthand or another way of referring to this, we thought, obvious point of the secrecy that has historically shielded litigation instructions between litigant and solicitor and lawyer. And that's a classic part of litigation privilege. And if the bank is right, then those are not kept secret, because you can ask about them. You can interrogate privileged instructions. You can ask questions and demand an answer to, well, who was at that meeting? Who gave instructions to RPC in 2021? There's nothing in this judgment of Mr. Justice Knowles prevents that question on privilege. And we say that would be an extraordinary outcome. In terms of the law, just the final point I need to make is this, that it's accepted now by the bank that litigation privilege and legal advice privilege may coexist. It is only now common ground on appeal. It was a major plank of the bank's case before the learned judge that they could not coexist. That if a communication attracted legal advice privilege, it could not, ex hypothesi, also be litigation privileged. That has, with respect, now rightly been abandoned. And the learned judge found against the bank on that point. And we don't need to go to that point, but it's important forensically because it's plain why the bank put so much effort into this point at first instance, because they were determined to take the analysis into the legal advice privilege jurisprudence channel, which is a different setting, not adversarial, not the same rationale, not the same scope or test. And that's why it's very important to understand that has now gone, and it's common ground that a party can claim litigation privilege and be entitled to make that claim on litigation privilege grounds. In other words, we say without being handicapped by requirements from legal advice privilege, which is a separate limb. I'm going to turn now to why we say with respect the judge was wrong, and as the flip side, why we respectfully submit our approach is the right one with the right result. I need to deal first with one final preliminary point in this regard, because the bank places great store by this alleged dichotomy between, on the one hand, communications, which the bank says are the stuff of privilege, and on the other, facts or information, which the bank says are not. And we say with respect that is a meaningless and unhelpful distinction to draw for this reason. Of course, privilege, as a rule of evidence, prevents disclosure of documents and thus communications, whether oral or written or a record of the same. You're talking about communications. Of course, that's right. But privilege is not designed to protect a right to keep the piece of paper confidential on which the advice is written from counsel. Nobody cares about that. What they care about is the contents, the information within the privileged communication. And what the bank can't do, which it tries to do in this case, is by dressing up its Part 18 request as an informational, factual inquiry to disguise the fact that what it's really doing, we say, is asking for the contents of a privileged communication, namely the person or persons who are privy to that for the client. That's what it's doing. And that's a very important red herring, as it were, to clear out of one's mind. Because the bank placed great store on that, because that's the way they managed to elevate their Part 18 question into a simple factual inquiry of the sort they could ask at the trial, for example.
It's really an interrogatory, isn't it? As we used to call it. It's really
it is,
a request
my lord, yeah.
for further information rather than a true disclosure.
Correct. I agree, my lord. It is. It's an interrogatory, and we said they're interrogate. The fact that the interrogation, the interrogatory, asks for a factual answer or information. Who was authorised? That is fact. It is information.
You accept that the interrogatory is relevant to the question of limitation.
We accept that because the bank had put it in issue, it falls to be an issue for the trial. And therefore, if there's relevant disclosure that goes to it, that will arise. Your Lordship will see how we put our case on limitation. Following inter alia your Lordship's case and the Riyadh case, we don't accept, and Alison and Horner, we don't accept that the knowledge of an agent can be relied upon for the purpose of Section 32 of the Limitation Act. We don't accept that at all. And that's what the bank is. But the bank says no, it can do that. It can rely upon the knowledge of, it says...
well, it depends, doesn't it? I mean, I think the Riyadh case, which I only vaguely remember, but I think it was a simple case of whether a solicitor who may have had knowledge of fraud or capable of having knowledge of fraud could start the limitation period running for the purposes of the client. And I think I held that it couldn't. But it's a very different thing when you're talking about Trust Company 124 of Liberia, when you have questions of attribution and knowledge and all sorts of things. I mean,
Yes.
you may be entirely right. All I'm saying is it's not automatic.
No, I'm not. But Your Lordship, do we accept it's relevant? We don't. We don't accept.
No, but you accept that they say it's relevant and that therefore it is something part of their case which needs to be determined.
Yes,
Yes.
as the bank.
Yeah,
As the
I
bank.
mean, I know you don't. We're not going to say anything about the case.
I'm not being fixed with some.
No,
acceptance
you're
of
not.
that.
I'm not asking you to be fixed.
And it's worth on this point testing it because, and I accept that for present purposes one doesn't decide whether that is or is going to be relevant for the trial judge. But just stopping there, Your Lordship knows that the bank now say that all they want is a bare list, quote unquote. It's
Yeah, well, they want to know who gives instructions on behalf of your client.
yeah, well, just it's
A list of people who give
a
instructions.
bare list of names.
Well, okay.
That's in their skeleton. At paragraph 49, subparagraph 1. But just pausing there, my lord, if one tests it this way, it is very difficult to see how a bare list of names, without more, can have any probative value at all. And for this reason, let's say there are 4 names. 4 names. How does that fit in? It can only really work in the way the bank wants it to work and suggests it can work if you go beyond that. Because it must be the case that to understand whether the extent to which Mr. X or Miss Y, in other words, people on that bare list, have actually had knowledge or control or relevant insight for attribution purposes, you need to go beyond that.
Well, won't there be cross-examination on what they knew at a relevant time in relation to these bonds?
But what you can't do by way of a leg up, we say, is to ask who is privy, who is giving the instructions.
Well, all you're going to be saying is, well, what you knew in 2008 is relevant to my case, the bank's case, because 10 years later you were still giving instructions on behalf of L30, and the witness will then have to say, well, true, I'm now giving instructions on behalf of L30, but actually that's irrelevant because since then I've got a new job and I'm doing this or that or the other, and we'll give an explanation. Or he'll say, yes, that's right, I've always been in the same job and I've been doing the same thing, in which case they'll say, well, we can rely on your knowledge in 2008. I mean, I'm just speculating as to how this case might go. But what I do find hard is in all this, we're sort of tiptoeing up against a really general principle. And yet you have no authority that you can point to that says, oh, of course, the person writing the communication to the solicitors is a piece of privileged information, a piece of that is privileged. And if it were right, all the examples we're struggling with, and my lord's come up with a couple, and I've come up with a couple, would surely have resulted in somebody saying, And of course, the communicator is as privileged as the communication.
Well, there is authority for that. In our sketch, there is authority. I'm going to come to it.
Which is your best authority for that?
Well, there's two important strands to this. First, the witness identity case law, the identity of a potential witness.
That's a discussion about who you're going to call to give evidence, which is obviously privileged as to the tactics of the litigation.
But that is the key point. And I'll go to the China national case now, because the Vice Chancellor said it must follow. We'll go to it now. He said it must follow that if the contents of the communication are privileged, the person giving it must follow.
Well, let's look at
must follow. And we say it must follow here.
Okay.
And just on that point, it is no more invariably the case that a potential witness's identity will betray something than the particular client representative who's giving the instructions. And I give this example. There could be a road traffic accident. There could be a host of people who saw it standing around at a bus stop, for example, or outside a nightclub. There are two cars involved, and the parties concerned, one solicitor goes and speaks to people in that group. The mere fact of having gone to somebody to ask them about it, they might have seen it, they remember anything, that doesn't tell you anything about the case. No, materially no more than the nature of the client representative, because that could well tell you something about how that counterparty is conducting the litigation. Could very well tell you in this cat and mouse. But let's go then, if I may. Can I give your lordship the references to this communication versus information fact distinction, just for your lordship's note? Can I just clear those away so I can go on to the China case, please? I've dealt with the information fact distinction. We say it's a false distinction. It doesn't go anywhere. The references, please, are the SRJ case, which is Authorities Bundle 23, paragraphs 21 and 27, where the court talks about information. Ablyazov, Mr. Justice Tier, tab 20, paragraphs 18 and 29, and the China National case, which I'm coming now, tab 10, paragraph 46. But in our submission, there is authority that the communicator of a privileged communication must necessarily is a privileged matter as part of the privilege for that communication. And I take you to the China National Authority. It's in divided 10. Starting at page 171, probably 175. And it's the Vice Chancellor, Sir Andrew Morritt. If one goes to paragraphs 5 and 6 and 7, just very briefly, it was a construction dispute that had led to arbitration, and in the course of that, a letter had been written by one of the parties which showed that it had probably got confidential information of another party from an employee or ex-employee. That's what it was about. So there were then these court proceedings to chase down the alleged breach of confidence in and about the arbitration. That was the point. And the issue was the protection or otherwise of exchanges with this individual who was going to be potentially a potential witness. So that was the issue. And if you go to paragraph 30, page 178, you can see the application that was made. This was the application for a disclosure order. And the consortium who were seeking it said, the evidence for the court demonstrates a strong prima facie case the fact that FE obtained from the potential witness information which he must have known was confidential, was being imparted to him in breach of duty of confidence owed as an employee or ex-employee to the consortium OGP. So that was what the court was being asked to order disclosure of. And then picking up paragraph 43, page 180, there was evidence that that this person was a potential witness. and counsel for the consortium disavow any wish to see the proof of evidence obtained. That's paragraph 43. And that instead there should be adverse inferences drawn. And the Vice-Chancellor then deals with the matter in paragraphs 44 to 46. And relevantly, for my purposes, it's really in, well, 44 sets out litigation privilege, that's what we're talking about. And 45, he says this, if he holds as such as part of the ratio. In the normal course of proceedings, a solicitor will interview and obtain proofs of evidence from all manner of potential witnesses for use in actual prospective litigation. Both the information given and the identity of the person supplying it are confidential and privileged unless and until the privilege is waived by that person giving evidence in the proceedings or some other equivalent action. And then in paragraph 46, he says this, if the information provided by and the identity of the potential witness is privileged information, then the claim to privilege made by Techint must preclude the grant of the order now sought by the consortium. And then further on, he says this, halfway down that paragraph, even if the information given by the potential witness indicated some earlier breach of a duty of confidence by him, or another, that cannot preclude privilege for the communication between him and Mr. Fenwick Elliott, the solicitor. Frequently, information given by a potential witness to a solicitor indicates the past commission of a crime or fraud. That is no ground for denying privilege in the communication, quite the opposite. If, as I conclude, the communication between the potential witness and Mr. Fenwick Elliott is privileged, then it must follow that the identity of the person giving the proof is similarly privileged. And we rely upon this analysis. We say is orthodox and correct. That you can't strip out from a privileged communication, which an instruction for litigation is, the giver of that communication, the maker of it. It doesn't matter that you call them the litigant or the client. It doesn't change the analysis. And if Justice Knowles is right, the court goes on to ask, at the second stage, well, would this give the game away? What would it give away? Because there is no logical reason why the same sort of extra analysis and burden on me wouldn't arise in a witness case. And that's plainly not the law. If the communication is privileged, so is the maker of it. And that is the law. That is the conventional law. And we say that accords with principle, the keeping secret, all the case law is all consistent with that approach. And it's not suggested by the bank that China National Petroleum Corp is wrongly decided. So they've got to explain why there's an absolute rule here for a potential witness, and I give my example of the road traffic thing, as opposed to the person giving instructions, but from the client, because that could be just as significant. Could be the person giving instructions is the person who is well known to be the institution's person to settle claims. Could be somebody who is known to be involved with the relevant quantum aspect. All sorts of relevant points could be given away. The number and seniority.
I suppose, Mr. Lord, you might look at it as a box. A privilege, litigation privilege, is a box, and this authority is about what happens right in the middle of the box. In other words, when you are preparing for trial, the solicitor is actively engaged in trying to get evidence to show that the car was going at 60 miles an hour instead of 20 miles an hour, or whatever it might be, and is talking to all sorts of people on behalf of the client to locate evidence. That's really very substantively the stuff of litigation privilege, which everybody accepts is you can't ask questions about. You can't say, before you got this expert witness, well, you might be able to, actually, it's a rather different question, but maybe it's a bad example. But what we're talking about in this case is the outer regions of the box or the sphere. In other words, the client talking to the solicitor about the case. And it's quite a big question to say, is the identity of the client privileged, or anybody acting on behalf of the client, particularly when it's relevant to the issue in the case. I mean, you keep on sort of dismissing my example of Trust Company 124 as being eccentric, but it's not really eccentric, because the question of who the client is relevant in many cases to the outcome of the case.
I must have put my answer wrong. I'm not suggesting that is not a relevant line of inquiry.
Yeah.
It absolutely is, totally is. All those questions. Who are the real brains behind this? Who's the real beneficiary? Of course that is, but we are not dealing with those sorts of questions in and of themselves. We are dealing with the question: who gives instructions in the litigation?
But why, if the solicitor gave evidence, let's say the solicitor for Trust Company 124 or L30 gives evidence about communications he had with third parties on behalf of his client and is cross-examined heavily about it, why could you not say to the solicitor in cross-examination, well, who gave you instructions about anything?
You couldn't ask. You couldn't ask that to my submission.
Never.
That's what you could not ask. But to answer your lordship's
never
point,
ask who gave instructions.
If forensically, if it is about privileged exchanges, if it's about did you go and buy a suit together, were you on the bus together, then you can ask those questions, and there may be a difficult question as to whether what you're talking about is really part of the privileged exchange. But in our appeal, that question doesn't arise. That nice question of are we in the box or outside the box doesn't arise, because we're plainly in the box, because the box is labelled instructions for litigation. That's the label. That is what the bank want to look inside. It doesn't matter where in that box this exchange takes place. It could be right at the beginning or the end. Doesn't matter. The whole point of that line of case law I took lordship to is to show the rationale in an adversarial matter. That's a box that you're in. You're safe in there. The rule of law depends upon you being safe to give instructions without worry. And one can see the choreography that would then happen. Someone would say, well, I better not ask Mr. X to be the conduit to my solicitor, because that could be opened up. I better find a way. It would be all sorts of unfortunate artifice could be understandably brought in if that box, I would say Pandora's box with respect, is going to be opened up.
If the issue in the case is who is Trust Company 124, which it often is in cases for waiver injunctions and so on, you're saying that it's impermissible to ask the solicitor for Trust Company 124 who's giving him instructions. I mean, that does sound a strange conclusion.
But I'm going to come to the other authorities we rely upon. This is the Client Identity Authority, which we say covers the case, the China National case. I'm going to come to cases, the Ablyazov case and the SRJ case, where client contact information was held to be privileged. Was held to be privileged. So even if this analysis of the Vice-Chancellor is not compelling, which we say it is, we say that's the end of the matter here. Because neatly...
There's an argument to say it's distinguishable. I mean, it's not saying that it's wrong, but the argument is it's distinguishable. And then you say Ablyazov, and presumably the argument will be the same, it's distinguishable.
Well, we see how Mr. Justice Tier dealt with it in Ablyazov. Yeah. So we have...
Which page is Ablyazov?
It's 478. It's behind divider 20. And this is with respect right on your lordship's point about a moreover. It's exactly the area, certainly the sort of area with which your lordship just texted me.
24 you want?
Beg your pardon? 47.
24.
I'm told it's
24.
478 in the electronic bundle.
Yeah. Okay.
Erroneously 474 in my hard copy, tab 20. This was Mr. Justice. Your Lordship may record there was very long-running litigation.
I very much recollect.
Most of the bar was involved
Yeah.
in one shape or form. Sadly, not me, but everyone else seemed to be. So there we are. And it went on for a long time, and Mr. Ablyazov was being sort of chased uphill and down dale before the courts.
I mean, everyone knew who the client was and who was giving instructions. It was a question which hill or which dale would you find him in?
That's right. That's right. But the question was, if one looks at Mr. Satir's judgment, paragraph 1, what was sought were the contact details that had been set up to enable Mr. Ablyazov to contact his litigation lawyers. That's what they were after. Now, on the bank's analysis, well, that's just information. That's just facts. None of that goes into the contents of any legal advice. So that was what was concerned. And then
this was in the context of his having been ordered to show up in court and not having done so.
Yes, and one sees how it was then dealt with.
Right. So can we look at why the judge said it wasn't?
Well, can I go to paragraph 6 just to show why the claimant sought it? Because there are parallels. The claimant in the Ablyazov case wanted this client contact, this contact information regarding the conference call facility and email facility, so that it can seek to track down the first defendant's location. That's paragraph 6. And then paragraph 8, and it's about 7 lines down. Today there is evidence from Adelshaw Goddard. Adelshaw Goddard and the first defendant have set up a conference call facility and email facility expressly for the purpose of giving and receiving confidential and privileged legal advice. The confidential details associated with those facilities are now sought. And the way the learned judge resolved it, his reasoning really starts paragraph 16 at page 483, and it runs through to paragraph 29, and I'm just going to point to the more important bits.
Yes.
As follows, paragraph 18, having referred to R. Cathcart and ex parte Campbell, whether it's a collateral fact. Mr. Satir said this: that observation illustrates that whether or not information, so nothing turns on that word, but information provided by a client to his solicitor is protected by legal and professional privilege, will depend upon the circumstances in which it is communicated by the client to his solicitor. So we say that there's an obvious chiming there with the China case. Then paragraph 19, he deals with the Manchester Crown Court case, where a person had left the scene of a crime in a taxi and taken to a solicitor's office. The police saw production of documents from the solicitor, which recorded the time of the applicant Rogers' arrival at the office, in order to establish whether the applicant Rogers was or wasn't the person who was taken by taxi to the solicitor's office. Then Lord Bingham, Chief Justice, said this, and then I won't read it out, but you will see, it starts at paragraph 20.
He said the record of the time on an attendance note was not a communication.
That's correct. And then he went on to say, towards the end, a record of appointment made does involve a communication between the client and the solicitor's office, but it's not, in my judgment, without more to be regarded as made in connection with legal advice. So the mere time of arrival is not, but a record of an appointment as a solicitor does involve a communication. And he held that it isn't without more to be regarded as made in connection with legal advice. But we'll see what Mr. Justice here held, but just pausing there, that isn't, our case involves communications by way of instructions for litigation. So it does satisfy Lord Bingham's filter test. And we say it plainly does. You are not dealing, we say, with a sort of collateral fact. You are dealing with something that is a privileged communication, prima facie. And that's the absolutely fundamental difference. And one can see that's how much
Could you look at paragraph 20 in the judgment of Mr. Justice Fulford, as he then was? As my Lord observed during argument, provided these details do no more than create the channel through which advice may later flow. Why is the name of the person doing more than creating the channel? And he concluded, Mr. Justice Fulford concluded that neither the identity of the person communicating, contacting the solicitor nor the telephone number were subject to LP.
But I relied on Mr. Justice Tears. He said this at 23. Mr. Smith relied upon both of these later decisions. However, I'm not persuaded they are analogous to the facts of the case before me.
Right.
And he says this: the function and nature of the conference call facility and email facility set up by agent is to enable the first event to seek and receive legal advice.
Yeah.
In my judgment, the connection between the telephone number and email address and the seeking and receiving legal advice in the present case is clear and manifest. Well, stopping there. The person authorised to give instructions on behalf of Loreley 30 is clearly and manifestly connected with the seeking of legal advice in the litigation. That's the whole purpose of this. It's the information sought is information which is manifestly connected to what one might call the privileged channel of communication.
Was this appealed, this decision?
I don't believe it was.
As many of them were.
And it's not said that this case is wrongly decided. So the way that Mr. Justice Tear then, he deals in paragraphs 27 and 28 with really Lord Bingham's point, my lord, in the Manchester case, about this point about the difference between the mere time of arrival.
So the real nub of the ratio of this case is in the last sentence of 26, is it? That the lines of communication were communicated in confidence for the purposes of taking legal advice. That's what it's really about.
The nub is in paragraph 24. The nub is the in my judgment, the connection point.
Yeah. It's a very special case, isn't it?
Paragraph 28, Mr. Justice Tear looks
it's a special case because Mr. Abliasov, who was obsessed with secrecy about everything, particularly where he was, had taken the trouble, under the cloak of privilege, to set up a secret method of communication intended that he could secretly get legal advice. So the judge said, well, when you do that, that is within the cloak of privilege. But it doesn't really tell you that every communication made protects the communicator.
Well, it can't affect the analysis or the intention in my submission. And in order to be able to make that good, you would have then to go into explaining. The party claim page will also have to go into explaining some of its kind of concern if the particular authorised representatives were disclosed.
I mean, about 20 minutes.
It would have to say, if I tell you about this, you'll realise this. And we say that's exactly what should not happen. Because in order to be able to answer the bank's point of who gives instruction, the answer may very well be, hypothetically, it's Mr. X, but subject to this, or it's Miss Y from this date. And we can't say, it's not right to say simply these 5 people do or have given instructions, but because as with all questions, in court and otherwise, it is very often the case that a complete answer is not a yes or no. It's not a bare list.
The judge said at 24 that he relied on the paragraph at 24 saying that the connection between, the judge had said, the connection between telephone number and email address and the seeking and receiving of legal advice was clear and manifest.
That's what Mr. Tear seems to be relying upon. And then the further point I'm picking up here is in 27, he deals with the idea, well, if in fact Lord Bingham is saying in Manchester Crown Court case, this was the case about the timing, the time the chap arrived at the solicitor's office, and the difference between the simple time he arrived that wasn't privileged and a record of his attending for advice that would potentially be a communication that could be privileged, that Mr. Tear picked up the words without more that Lord Bingham had used in the Manchester Crown Court passage, to which I just took your lordship, And he says in 29, in 28, he says this in Justice Tier, the third line. Further, the giving of information in confidence for the purposes of seeking and receiving legal advice appears to me to amount to the additional requirements said to be necessary by Lord Bingham, without more. But in our case, we have that. In our case, you have people on behalf of Loreley 30 who have been authorised to give legal litigation instructions. So, if you like, the necessary connection between the client details and the giving of a privileged communication is made out in our case. Our case is a fortiori a privileged communication. It's much more privileged than the question of a note of someone arriving at the solicitor's office for the first time, because it assumes actual instructions to conduct litigation, and therefore it's way beyond, it's way further into the privileged box than these examples. And Mr. Justice Tier said this in paragraph 29. I have therefore concluded that the telephone number and email address in the present case are protected from disclosure by legal professional privilege. And he goes on. That conclusion is supported by the observation of Lord Justice James in Re Cathcart ex parte Campbell and is not inconsistent with the decision and reasoning in R and Manchester Crown Court ex parte Rogers. So we say, pausing there, if you look at what the bank is asking for, which is disclosure of the persons authorised to give instructions to their litigation solicitor for the litigation, it's plainly made out by the paragraph 24 Ablyazov test. That is information. There's information which is manifestly connected with the giving and receiving of legal advice. That's what it's doing. That's its very purpose. It's not collateral at the time of arriving, or did you buy a suit, or some other by the by. It's absolutely at the heart of things. And that's why we say that whether one looks at this in terms of the Sir Andrew Moritz analysis to say it must follow as night follows day, if the communication is privileged, the giver, the maker of it, the communicant is part of it and privileged, which we say is correct, or whether you say, Mr. Tier, that even if that's not right, you need something more per Lord Bingham, then if you've got a clear and manifest connection between the said gobbet and the giving of, sort of seeking of legal advice, it's privileged. And that's what we're talking about. That's what the bank want. The bank want to know who has sought legal advice in the present case about the case. That's what they're asking. And in my submission, none of these cases that the bank relied upon would end up with that being disclosable. And it's not the same thing as who is your client. Who is your client in the litigation advice privilege is not the question we're dealing with, and that it is apt to confuse and distract. We are dealing with litigation privilege with its own sensitivities and its own box of protection, to pick up my Lord's point. And it's fundamental to keep those two tracks different and not to let the legal advice privilege requirements to establish a client, still less with a little boost from Three Rivers number 5, I'll come back to that, to let that bleed into the litigation privilege analysis in our case. And that's the mistake with respect that the learned judge fell into. He was drawn down that line by the bank, and I'm afraid he took a wrong turn. So, in terms of your Lordship's note, there is not just the China National case on witness identity. There is the case on experts, and their identity is also held to be confidential. And we've given the reference there. It's the case of S, County Council and B, so Divider 9, starting at page 147. So there are two authorities on witness identity. One factual, that's China National. One expert, that's S County Council and B in the Family Division. And in both cases, it was held to be privileged. So that's one strand of jurisprudence which we rely. And the other strand are the Ablyazov case, and supported by the analysis in the case of SRJ, to which I will go. SRJ case behind Divider 23. starting at page 508. And your Lordship will probably remember this case. This was quite a well publicised case about the anonymous blogger. And it may touch upon the point your Lordship put to me earlier about the way litigation is moving into internet territory. Your Lordship will see this. So David Evie was the judge. And there was applications for the disclosure of the name of the defendant, who was a former client, author of at least 2 blogs in which confidential information was published. So there have been anonymous blogs on the internet, and the party complaining about the breach of confidence wanted to track down the author, the anonymous blogger, as it were. And then if we go, please, to page 507, so 511, paragraphs 7 and 8, your Lordship will see that in paragraphs 7, 8 and 9, Sir David Eadie goes through the arguments and the cases which your Lordship has seen. Lord Bingham in Manchester Crown Court, paragraph 9, is Mr. Justice Fulford's case, which your Lordship has asked me about. And then paragraph 10 at page 513, the no judge said this: I must now turn to the important decision of Mr. Justice Tier in JSC, BTA Bank and Abbey Azov. Then 11, it is important to have regard to the way in which Mr. Justice Tier directed himself. And then he has regard to paragraph 13 of Abbey Azov, and then paragraph 24, that's paragraph 12. One can see that and then 13 and 14 and 15, you can see that Sir David Eadie basically goes through Mr. Justice Tier's approach, including in paragraph 15, noting Mr. Justice Tier's finding that if there was an additional requirement for Lord Bingham in Rogers, that might well be fulfilled in circumstances where the client has given information in confidence for the purposes of seeking and receiving legal advice. So we come back to that as the touchstone. And then paragraph 21, page 516, talks about information. And then crucially, the ratio is at paragraph 27 at page 518. I've come to the conclusion, in the light of the circumstances of this unusual case, and in particular the evidence given by a solicitor, that the information as to the returned identity was indeed the subject of legal professional privilege, and thus protected. Even if it were not, there are powerful reasons not to override the duty of confidence. It was not simply a piece of neutral background information, as would generally be the case with a client's name, since both he and his solicitor were well aware that the claimant was keen to establish his identity for perfectly legitimate reasons. It was accordingly central to their discussions about the retainer that the confidentiality should be maintained. But it's plain from this decision that in SRJ that it is following Mr. Justice Tier's analysis, so it's approving that, so it's a second authority going along those lines. And the distinction, we say, the relevant distinction is between neutral background information on the one hand, and information which goes to the privileged communication, which is manifestly connected to it. And we say that when you are looking at the communicator of litigation instructions, you are clearly on the privileged side of the line. And you are miles away from the time you arrived at the office or some other piece of neutral information. That is going to be, material in all sorts of pieces of litigation, not least every single piece of litigation where control or knowledge of a corporate is concerned. This line of interrogation, of interrogatories, is going to be pursued if we are wrong on this appeal. Because it will be said, we can ask you all about your litigation privilege. We can ask you, in effect, we can peek behind that and say, well, who was giving these privilege instructions? Because that will be a leg up for us to start to build our case on knowledge or control. And that is 100% what legal professional privilege is designed to stop. Designed to stop a shield. It's designed to create a shield to stop parties using information that is protected, that lies behind that curtain. So people can unburden themselves and take advice in litigation freely and openly for the rule of law. And this would be a very, very dangerous precedent, we respectfully submit.
So that's your floodgates argument.
in both Ablyazov and SRJ, there was evidence that the particular information, whether the mode of communication with Mr. Ablyazov or the identity of the blogger, were actually communicated to the solicitors for the purpose of advice about those matters. Is there any corresponding evidence in this case to do with the confidential communication to the solicitors of the people who were going to give instructions in the litigation? That's something which I think you had an opportunity to put in evidence about, but chose not to.
Because we say that involves requiring us to go into the very matters that are protected. Because the starting point...
So you say it would have been difficult for you for that reason to put in evidence about it, but do you accept that is a factual distinction between those cases and this? That is to say, in those cases there was that evidence, whereas in this case there doesn't seem to be.
Well, but my lord, in our case, the information that is sought is in relation to instructions. It's not, can we have a telephone number? So you start it on our facts with a request for us to explain why we shouldn't say who the person is or the people in the box. So that's the starting point. It's different from simply contact details. It's different in speech from contact details or the client ID. It is different because you've already travelled into the box. You are accepting that the debate is, do we have to tell the court why we don't want to reveal who it is that is giving instructions, privileged instructions, in the box? Do we have to say to the court, it will give something away? Is that going to be enough? Do we have to say, it'll give something away because? And if we do say that, will it be said against us? Well, now you've put in issue this question of whether it's really the Japanese branch or the Tokyo branch or the American branch of the bank, or whether it's some bit of the company or some bit of the trust company. You put that in issue, so you waive that privilege, so you can't cherry pick. We've got to go the whole hog. We have to have all this information that you're trying to just to cherry pick, and that is the sort of debate that we say as a matter of principle and authority should not be countenanced in this sort of case.
Well, could it be said that privilege is a right to withhold relevant information from the court, and therefore it has to be claimed, and if justified, it has to be, if challenged, it has to be explained and justified. If that creates difficulty for the person claiming the privilege, why should the balance come down in favour of allowing the relevant information to go before the court?
Well, because with respect, we haven't set up some unusual claim to privilege. The communication that's being interrogated, we say, are litigation instructions. It's not the time of arrival. It's not a telephone number. It's not that sort of case. It is litigation instructions. And what is asked is, essentially, who gave them? Who is the person who is speaking the communication? And we say that by definition, you are asking somebody to... The privilege is over the communication. And the communication...
Can I ask you something? In a normal case, where a public company is a claimant or a defendant, the board minutes are requested on disclosure of the decision to start the litigation. And what is redacted from those board minutes is only the substance of the legal advice. But the board minutes themselves, including discussion between the decision makers as to the issue in the case, is not disclosed, not protected by privilege, even if the solicitor is present at the board meeting, yes, which is normally the case. Why is that the case? Because I would expect, if you're right, that the identity of the people discussing the case at the board would be privileged.
No, that's not right, my lord, because there's a difference between the decision by the company, the party, to litigate. That's its decision, which it takes, not privileged.
Why? There's surely the minute that says, and we instruct, we the board, instructs Director X to give instructions to the solicitors, is not privileged.
Well, that is privileged. That will be privileged. That will be privileged. And your logic posits a sort of neat initial example. But if the who instructs, there's a difference between deciding to litigate, the company decision, the company takes a decision to litigate and make a record of it, and the board decide. And if you like, the attendant legal advice is redacted, because that's obviously privileged. We say so would be the instructions to litigate. Not the decision to litigate, but how that's then going to be implemented. In other words, the prosecution of the litigation by that company is privileged and will be redacted. And it might say, well, we instruct Mr. X to do with liability, Miss Y to do quantum, because it's known that Miss Y is the person that the company always use to settle cases, big, difficult cases. And we get to see, do we, the counterparty, that Miss Y is going to handle that case, whose only role in the company is to handle risk and settlement for the bank. We get to see that at the beginning, and our claim think, right, this is claim's going to settle, they're going to pay some money here, that's great. Because if we're wrong, that information comes out to the counterparty. We say that's plainly wrong. That's plainly wrong. That will be gold dust in lots and lots of cases. It will be sought across the board. May I just, I'm going to try and stop by just after roughly past, so I'm conscious I can't take up much. We've agreed between us that I may have 10 or so more minutes more as the appellant, but I'm conscious I need to only have that extent of the apportionment. So I've made my submissions as those two separate lines of authority, which show why this information the bank seek is falsely privileged. Both those lines of authority apply. We say it's not just that they're wrong, that they are materially indistinguishable on our case.
About half an hour ago, you were going to tell us why the judge was wrong, and I wrote down, judge was wrong.
Yes.
Would you like to do that?
When we go to the judgment behind divided 5, I think page 70. Come back. The learned judge sets out legal professional privilege, starting at paragraph 16, page 77. Don't need to go through all that. We've gone through all that. So far so good. Good. 16, 17, 18, setting out the background. Then paragraph 20, page 79, he sets out the argument. And then in paragraph 25, page 80, it's where we say he goes wrong. In my judgment, the answer to the question whether the identity of a person communicating with a lawyer is privileged lies in whether two requirements are met. First, whether the communication is privileged. Second, whether that privilege will be undermined by the disclosure of identity sought. We say he went wrong for this reason, because he's positing that both these requirements have got to be established by Loreley 30 in this case. And we say, so consistent with our submission on China National Petroleum and that line of jurisprudence, that the identity of the communicant or communicator of litigation instructions is privileged because it must follow as a result of the communication itself that they are uttering being privileged. And therefore, on that analysis, you simply, there's one question to ask. Is the communication privileged? And we say it is, and it embodies the identity of the person making it, which is the information sought on this appeal of the bank. And that involves, we say, a conventional and orthodox dispatch of this dispute, this issue. Because it applies a single test, which is, in effect, is litigation privilege made out for the particular communication concerned? When you understand what that communication is properly and on authority to be, the answer is very simple. Litigation instructions from an authorised representative of a party, that is privileged, full stop. So his error, that's an error. And then what the judge goes on, he posits a second requirement. So a further test, so two tests here, not just the Three Rivers test, was that communication, and so on, but this, whether the privilege will be undermined by the disclosure of identity. So what he seems to be envisaging, that even if privileged, even the communication is privileged, Loreley has to go on to a second test or stage, which is to show that the privilege will be undermined by disclosure of identity.
So what he may be saying is unless there is evidence that the identity of the person giving the instructions would give information away about the detail of the communication, the communicator is not prima facie privileged.
But that would undermine all the case of litigation privilege. If this was the requirement, it's effectively creating a twin test, not a single test.
Well, I mean, I think the twin test is slightly confusing, really. And I think what he's saying is the communicator is not necessarily part of the communication. It may be. And there are some cases where it is. See the examples you've given. And they all, as my lord pointed out, turn on evidence having been given that the identity of the communicator was indeed going to give away some of the content of the communication. And so he cites it as a two-stage test, and I'm always suspicious of two-stage tests that suddenly appear 300 years after the invention of a doctrine. But I think that's the explanation of what he's saying that you have to meet.
Well, first, it wasn't a test that was debated in argument or canvassed by other parties.
No, but given his due, he had to think about it. It's a difficult question.
But what it involves in our submission is the corruption or distortion of the well-established hundreds of years old test, because it does involve a dissection of matter and exchanges that would on the face be privileged. It's an additional inquiry. However you run at it, it's an additional inquiry. And he did not, with respect, grapple with my submission about that the identity is part of the communication which is privileged, and therefore it must follow that the identity is protected. He did not grapple with that. He records the submission that I made to that effect in paragraph 39, at page 84. But with respect to the early judge, he doesn't address that submission. He proceeds on the basis with respect, and he doesn't refer to the China National Authority or the S County Council and B, those two witness cases. He doesn't refer to those, and with respect, he's overlooked that point. The submission was made, but his reasoning proceeds on the basis that the identity of someone authorised to give instruction is separate from the communication itself. It seems to be the premise of his approach. That must be the case. And we say that is contrary to the right approach, which, as explained by Sir Andrew Morritt, which that it's all part and parcel of a privileged communication. And you don't get into this sort of dissection or subdivision of how forensically important it may or may not be. Because if that was right, there would be lots of communication between litigation that may not give the game away. And it can't be right that if the communication is privileged, and I'm right that sweeps up the maker of the communication, the giver of it, that there's another requirement to consider, which is will that be undermined in some way? That's a level of analysis and concern about the forensic impact, for example, that will be impossible in practice to manage. How would one litigant know how these questions might sound in the other litigant's hands? They wouldn't know how important it was. In most cases, who is handling the case and giving instructions is relevant.
Well, you say, I mean, just to be clear, what I've written down is that you say it is wrong that what the judge was really saying was that the identity of the communicator will only itself be privileged if there is evidence that disclosing that identity would disclose or give clues as to the content of the communication.
He didn't deal with my first submission, which was that which I'm going to call the China national principle.
Yeah, but you say what I've just put to you is wrong anyway.
I do, but he didn't deal with it.
Because always the identity of a communicator of privileged information is, you say, itself privileged.
Yes, prima facie privileged. Yes, I do say that.
Well, is it prima facie or is it privileged?
Well, it's privileged. It is privileged. Yeah. It is privileged. Because the privilege is through a communication, and that necessarily involves a transmitter or communicator. And if the judge is right, it's impossible to see why witnesses should be in a different case. Because the client authorization point could be just as significant to betray the strategy or the case thinking as whether you go and ask a possible bystander who may or may not have seen something.
And you say he didn't deal with that.
He didn't deal with it. He didn't with respect. He appears to have overlooked that point and proceeded on the basis, well, the client, the identity of the persons in this case is separate from the instructions that this person is giving. He sort of seems to assume it must be a separate thing you're looking at, and see whether that separate thing is privileged, i.e. the identity. And then he goes and say, well, no, because there's no evidence that it's going to undermine the privilege. But it's not really very clear how it's hard to follow the analysis in that case, and it's hard to see how that would be an answer in any event to the second way I put it, which is the Ablyazov and SRJ way of putting it, which is that this piece of information, namely the identity of the persons authorised to give instructions, that per Ablyazov is clearly manifestly connected with the seeking of legal advice, do litigation. But that's the very purpose of this person being involved. To set up, to be the channel. And that channel is a protected channel. And to see who is in the channel and for how long is potentially vital information in an adversarial context. And it's important to remember that litigation privilege recognises that contest aspect.
Mr. Lord, I'm not sure that suggesting that the judge didn't deal with your primary point is fair, because if one picks it up at paragraph 38, he links the citation of China National and S with your argument relating to the zone of privacy, which, if I may say so, I thought played quite a large part in your written skeleton argument, but in your oral submissions appears to have not quite the same significance. And following on from that zone of privacy argument, the judge deals with it in subsequent paragraphs and then turns to the point which my Lord Lord Justice Mayles has made, namely the absence of evidence. So I don't think, with respect, it is fair to say the judge really didn't tackle the point.
Well, in paragraph 39, paragraph 39, he records the submission. The identity is contained in communications that are privileged. So that's the first limb point. And the judge seems to assume that couldn't be enough. I'll put it differently. He seems to assume that couldn't be enough. He doesn't explain why the China national approach is wrong. I'll put it another way.
Well, he's also linking it with what appears to be in the argument you're putting before the court, namely linking those points with the zone of privacy.
Well,
Maybe it's not going to take it any further, but I didn't think it's a fair way of
well,
describing
then
it.
if I don't mean to be unfair to the judge. So we say that the judgment doesn't really grapple with, and we say, as it should have done, follow Sir Andrew Morritt's approach to privileged communications per the China National and then the other supporting case. And we say that if we're wrong about that, we say that the Ablyazov, the Ablyazov reasoning, which is here, was also made out. In paragraph 29 of the judgment, the judge records the point which Justice Tier was looking at the connection between the telephone number and email address and the seeking and receiving legal advice being clear and manifest. So it was disclosure of a channel of communication. So what's happening here, we say, is indistinguishable, because what the bank is interrogating is that channel of communication. It says the channel is the litigation instruction, the giving of the instructions and the authorising of instructions. And we want to know who is the people in that channel. And we say that what they are doing is interrogating a privileged channel of communication, which for these purposes, it must be taken to include the relevant conduct of litigation. Litigation instructions, we're not talking about buying a suit here, we're talking about how the litigation is to be conducted. That's what the bank wants to know. So
You might say that the interrogatory is inappropriate because it is of too general a nature, and even if the judge is right, this is fishing, really. But that's not the way you've ever put it.
it's more difficult to say that now, Mel. The trouble is it's more difficult, as your Lordship knows, under the Part 18. Parties are entitled to fish a bit more, as it were, than they perhaps would have been.
I mean, I'm sort of concerned by the way this case is staged, because normally in a disclosure application, one would be arguing about a particular communication. So, and I mean, I know I keep on coming back to the old days. You'll have to forgive me for that. It's age. But in part 2 of the list, when you gave discovery, and I think it is still the same in theory, you had to identify all the documents that were privileged from disclosure. And that was so the other side could challenge the claim to privilege. And when you had, if you look at Three Rivers, I'm sure they were cases where the challenge was to categories of documents. It was in ENRC too. And it was a particular, you could identify a particular document and say, is this document privileged? And if you were doing that here, then they would be able to say, this is an attendance note of a conference with counsel. The identity of the, you would be able to say the identity of the attendees is confidential because it will give you information as to what we were talking about, which is not allowed. If it's a communication from Mr. X of Trust Company 124 to the solicitor instructing the commencement of proceedings, they would be able to say, well, that's not privileged. Mr. X, the identity of Mr. X is not privileged. But here, we haven't got that ability. All we've got is this interrogatory, which actually makes it quite actually diffuse, because as I said in ENRC, privilege attaches only to a single communication.
Well, can I? But it's a very fair point your Lordship makes, and the answer is the rather quirky way it arose here, because this issue arose because Mr. Justice Pickett was persuaded by the bank to make an order to give some early disclosure. So if one goes in the supplemental bundle, to page, if I get the numbers right, page 79, but relevantly 81, Mr. Justice Pickett in paragraphs 2 to 3 ordered what effectively advanced disclosure of particular documents the bank had asked to see. So it took this out of kilter. So, and so that was the documents that were sought, and the ability to claim privilege was obviously preserved in paragraph 3, and the information in the Part 18 request was covered by paragraphs 6 to 7 of this order, over leaf at page 82.
And have board minutes been discussed?
And I'm going to show you, Lordship, the documents now, because they're in small copies. So just for the completeness, the Part 18 answer is at page 57 to 59.
Hang on, just give me a second.
And then I'll give you the documents. So there's the
Part 18 answer is
the relevant Part 18 answer is at pages 57 to 58 of the supplementary bundle.
that's the agreed case memorandum for that.
But you can see it's request 17. That was the matter for Justice Knowles. That was the one answer that Credit Suisse pressed to Mr. Justice Knowles.
So not entitled.
It's the answer as well. So that was the question. And then the answer is at page is at on page 58, not entitled. And that's what spawned the bank's application to Justice Robin Knowles. And then the documents were disclosed but were redacted. And so your Lordship sees what they were. They're in the same bundle. There were board minutes and an engagement letter. So 191 is one of the board minutes. So to pick up your Lordship's point, in my submission, my clients did very fairly distinguish between what was a privileged communication or a document that contained a part privileged and a part non-privileged communication. They did exactly that exercise.
Okay, 198 as terms of business.
Sorry, it's 191 is I meant to say. Is that not right? Board minutes. Perhaps I've got the wrong number.
Okay.
I want the minutes of the. I'll start with the minutes, if I may. I'm trying to adjust. I'm trying to adjust the numbers. In my copy, it's 187.
Okay.
If that's the right one.
I've got minutes of the meeting of the 7th of November 2019.
Yes, sorry. I was trying to adjust. I shouldn't have done that. Yes.
It's 189. Yeah.
So 187. Lordship can see that we did disclose board minutes, but we redacted what we said was legally privileged material. And then the next document is the engagement letter. Your Lordship's right at 191. And again, we adopted the right approach. We say we disclosed a document which had non-privileged aspects and privileged communication.
So you did not redact the two people present at the board minutes.
No.
The board meeting.
Correct. But we did redact material that would show what we say are privileged matters, and that would, we say, encompass what we're now debating. It's a perfectly proper distinction. And correctly
what
drawn.
is the difference between the black bits and the blue bits? The black bits say LP stroke.
I think blue is irrelevant and black is privileged, I think.
Thank you.
And then the engagement letter is at 191. Thank you for your instructions. So it's about instructions, and your Lordship will see.
Hang on. Just so RPC wrote to L30, dear sirs, Mr. Hibbert, Tom Hibbert. Thank you for your instructions, statement of your objectives. So you didn't think it was all your discussion about terms of business with the solicitors is not privileged?
No, well that was just standard exchanges about.
Well, it's not that standard. It's all about capping liability at £3 million. All that, but anyway, that's
well. Whether that could have been held back is another matter. The question is whether the I'm showing your Lordship how this arose
no, I mean it's very interesting how much is disclosed actually, and the identity of the people at the board meeting, surely that gives them the answer they want to know, doesn't it?
Well, I don't know whether it does, but what they aren't allowed to know. Mr. Hibbert explains in his witness evidence, paragraph 28 of his statement, supplemental bundle, page 237. He explains the redaction to 6.2. He explains.
So you'll have to give me that reference again.
Supplemental bundle, page 237. Mr. Hibbert explains in his witness statement for Mr. Justice Robin Knowles. He explains in that statement the various redactions. Starts at page 236 and goes through to 238.
Which paragraphs are you talking
Well,
about?
paragraph. I mean, Mr. Hibbert sets out the basis of the redactions, and the paragraph.
Which paragraph in the witness statement?
Paragraph 27 is the most important. Paragraphs 23 to 32 do provide evidence from Loreley 30 as to why they made the redactions. It does explain that, and it does explain we submit it is sufficient basis to claim litigation privilege in answer to my Lord Justice Males's question to me. So I wanted to recall that there is that evidence. There was that evidence, and I'm going to rely upon that generally, but specifically, paragraph 27 is important because the bank is particularly interested, I think, in paragraph 6.2 for the reason that Mr. Hibbert explains in paragraph 27 why that redaction was carried out.
So, which communication is privileged in the identity of the communicator claimed for? Is there any communication in this bundle with the name of the person blocked out?
Well, here, 6.2 is.
Sorry,
6.1. 6.1.
6.1 of what? Of this affidavit statement.
Does it say that here? Does it say that? Sorry, it's paragraph 28. Sorry.
28 in this statement?
Yes, sorry, my lord, yes.
That's redaction 6.
Yes, my lord.
That's from the board minutes, is it?
No, it's the engagement letter.
Oh, the engagement letter.
It's explaining why that's been blocked out.
Yes, but what I'm concerned about is there isn't a name on the engagement letter at all. It's written by Mr. Hibbert to L30 without a name anywhere in it. So normally when you're claiming privilege, and I'm sorry to go on about this, but I think it's actually quite important. Normally when you're claiming privilege, you claim privilege for a communication, if it's a written communication, email, letter, document, video, whatever it is. In this case, there is a generic question that is apparently being asked, to which you are required to answer, and that is equivalent to an interrogatory, which is equivalent to a question they say they're entitled to ask in cross-examination. And the purpose of asking it in advance is that it saves time for the case, right? If they're not entitled to ask it, then you're right and you win the appeal. If just thinking aloud, if I'd been you, possibly, I would have said, this is a funny question. It's very general and it looks like it's related to privileged material. But anyway, you can only ask this question in relation to a communication, identified communication. Which communication are you talking about? Now, that's not being done. So we're talking about a generic issue,
yes,
which I find, I've always been struggling with this case.
Well, but I accept that, and that's why I made my submission about the bare list. I made that submission earlier because I do agree that for this to take its normal forensic precision, you'd expect them to say, there'd be some follow-up questions or there would be a target. And the bank have not done that.
But is there something in the limitation argument that entitles them to ask this question? Because one of the other things I'm sort of struggling with is what is really the issue? Where is the issue identified to which it is said this interrogatory goes?
Well, we don't accept that it is relevant. And importantly, and it's in answer to your question to me, the reason it's put in this rather sort of generic way, we say, with the bare list being sought, just the names of anyone who's ever authorised litigation, is, we say, because Credit Suisse don't want to give it that precision, because that will expose that they are interrogating privileged exchanges. And because they keep it at that high level of abstraction, they try, for instance, to mask the fact that your Lordship is saying to me exactly correctly with respect. What they're really doing is starting the questioning that would be, well, when and what and who, because it doesn't make any sense otherwise. It's a by-the-by question. And they say no, because obviously we've been through a tussle. They've said, no, we're not going to go any further than the bare list. And one can see why they've had to say that, because they recognise that any further, which we said they've obviously got to go to make any use of this, is going to give the game away, to show they are in the box, the protected box. And they're pretending they're hovering on the edge, just saying, well, what are the names of the people who were around the edge of the box? And that's not. And the reason they want the information, the reason they want it is given away in their skeleton. It's given away in their skeleton in paragraph. It's in paragraph. It's in paragraph 7. It's in paragraphs. It's paragraph 7, subparagraph 3. And they say this in the skeleton.
Sorry, let me just get it.
Yeah. 7.3 CS contends that the question of whose knowledge is to be taken into account is highly fact-sensitive. And the extent to which L30's claims were in fact devised by and are being prosecuted by PFW and ICB is highly relevant. So what they want to find out, what lies behind this, is a wish to be able to ask questions about the way in which litigation claims of Loreley 13 were devised and are being prosecuted. Now, if one takes a step back, we say that you couldn't have a more paradigm example of protected matters. They can't be allowed to begin to burrow into those matters. And this is what they're doing. They're trying to take a little tiny baby step into the box. That's what they want to do. And one can see where this will go. They'll say at trial, I know you can't do adverse inferences, my lord, I know all that, and Mr. Lord's claiming privilege, but we're quite surprised that we didn't hear from Mr. X and Miss Y and Miss Z. Anyway, there we are. See where it's all going.
Can I ask that the party's juniors look over the adjournment of what the current rules are about listing privileged documents in the disclosure lists? Either under the disclosure pilot or under the normal rules. I mean, you could even look at the 1999 RSC because that's such a good book. But because it does seem to me here that there's an elision in the judge's judgment. We don't really understand why the question is being asked. And even if you're wrong, that generally there is a rule that the communicator is always privileged if it's a privileged communication, which you'll probably have observed the bench is not absolutely enamoured with at first sight. You may be right that this question is a bridge too far. And you may also be right about your baby steps argument, which I slightly see. I was surprised. No doubt Ms. Oppenheimer will tell us why this is all absolutely fine. But the history has been slightly ignored. And you've just shown us quite interesting history of Mr. Justice Picken, followed by a question. And we don't have interrogatories anymore, do we? Because it's all been amalgamated.
Into Part 18.
Part 18. So what used to be requests for further and better particulars and interrogatories is now all in Part 18, requests for further information. So again, it might be worth looking at that. I'm sorry to bang on about it, but that was the concern I really had about this.
Well, your Lordship is right to raise that as an aspect, because that is our concern. We do think this is the thin end of the wedge. For it to have any sort of relevance, it's got in the end to descend into the particulars. It must come down to, well, who was authorising what, and what were they doing, and when, in the scheme of
Well,
device.
your submission, if I may help you for a minute, Mr. Lord,
That'd be nice.
is not that this is the floodgates and this is going to be done in every... Well, it is that it cannot be right that in any case where nothing very specific is in issue, the first question you can ask in a request for further information is who's giving instructions, because that really has to be relevant to something pretty clear before it can be relevant to us.
You could do it in every case. Parties will find a way to make that, what I'm going to call that secret channel of communication, they'll find a way to make that arguably relevant, so they can get a handle on who is involved in the litigation for the client.
You can play the
They
man.
will. Every case they will. They will. I'm afraid they will, because they'll say, well, it goes to this or that. And of course, the other party will say no. The court will say, well, I can't decide that. We don't have pre-trial, it's going to be a trial. It's typical approach now to not to waste time on interlocutory skirmishing, to move it all down. So then you'll saddle with disclosure. Well, Mr. Lord, you've accepted it's an issue on the bank's case, so you've got to look at it as if it's relevant potentially. And then we've been sort of drawn down this route. But we say we shouldn't. Privilege should have protected us. We were entitled to stand and fight on that shield, my lord.
In order to give yourself a bit more time in reply, would you be best to call it a day and hear what Ms. Oppenheimer said?
I haven't covered some points, but I've certainly covered the gravamen of my submission.
Well, we've got your written submissions and we've read them carefully. Anything else from Mr.
Did I have any?
Thank you, Mr. Lord. Ms. Oppenheimer.
My lords, my lady, can I deal first with the point that the Master of the Rolls was just discussing about how this has all arisen and why it's relevant? I think we do need to go to the pleadings for that. Can I just remind your lordships and my lady of the entities that we need to have in mind here? We've got Loreley 30, the SPV, who are the claimant. But the entities we're interested in are IKB, the German bank that set up and operated the Rhineland programme, of which Loreley 30 formed a part, and KfW, that is the German bank which rescued IKB in the financial crisis and has since controlled Loreley. And it's probably easier if I just do this by reference to the pleadings. If you take the core bundle, at tab 8, you'll find the re-amended defence. If you go to page 273 in the hard copy version, I don't know what that means, I'm afraid, for Master Rolls online, but it's paragraph 104, 3b. And this is going to the issue of attribution of knowledge.
So this is 104.3b of the particulars of claim.
The re-amended defence.
This is 104.3b of the re-amended defence.
Yes, if there's internal page numbering of that defence 93 in the middle, and the bundle numbering.
That's 274 in the electronic bundle, yeah.
Perhaps just to give that to help rather than diving straight into the defence, so you can see what that's responding to. 2 pages. So if we just go back 2 pages, you can see where the start of the case on section 32 arises.
What, as to the knowledge of IKB and
yes,
or IKB?
so well, it begins at paragraph on page 270.
Which para?
Para 100. Time barred. It has been asserted that Loreley 30's claim is not time barred on the basis, this is right at the bottom of the page, that it is entitled to rely upon section 32 of the Limitation Act. And then Credit Suisse sets out its case, even if Loreley were able to satisfy the court that section 30 applied, then we deal with how, when time starts to run, and the knowledge point, and what the defendants intend to rely on. knowledge of IKB, the knowledge of KFW. And then you get into the paragraphs dealing with attribution.
So they could, with reasonable diligence, have discovered the fraud. That's the case.
Yeah. And then the paragraph where the sort of crescendo to this is at 104 B, where I initially took you to. That, the defendants will rely on the fact that KFW initiated and or otherwise was involved in the decision to launch the present litigation. And then the facts that will be referred to. So that's Credit Suisse's case on attribution. And then in the reply, if you go forward in the bundle to page 444, paragraph 67(3)(g.
Sorry, can you give me those again?
Sorry, so it's tab 9, paragraph 67(g), it's page 444 of my bundle. You'll see it's just the subparagraph, the penultimate subparagraph on the page. The emails referred to in subparagraph 1043B are admitted as documents. Subparagraph 1043B otherwise addresses matters covered by litigation privilege to which Loreley 30 does not plead in response.
So 1043B says KFW initiated and was otherwise involved in the decision to launch the present litigation.
Yes, and it appears
and
it may be.
instructing.
Yeah, and it appears it may be providing instructions to RPC on behalf of Loreley 30.
So the pre-action correspondence came from the General Counsel of KFW.
Right. I mean, if your auditors are interested, you can go on reading in that paragraph of the defence reliance on matters set out in the board minutes. Obviously sets out quite a detailed pleaded case as to why Credit Suisse says they consider that KFW was involved in the decision and is the entity that may be instructing Loreley and instructing Reynold Porter Chamberlain.
So it all goes to whose knowledge, who could reasonably have discovered the fraud. You say KFW could reasonably have discovered the fraud, and they're the guiding mind of L30, and they say, we're not telling you.
Exactly. That's exactly right. Well, and that is...
It's a bit difficult, isn't it, to see what more you're going to get than you already have from the pre-action correspondence. I mean, suppose the names you get are KFW names. That will simply confirm what you already know. Suppose they're not, well, that won't take you anywhere. I mean, what is this really all about?
Well, I'm not sure it's correct. We do have a complete picture. That may be the way if my lords allow this appeal, that's how this case will need to proceed. But I don't think we accept that's the case, that this information wouldn't add anything to what is known already.
Why not? Because you say you already plead that KFW's General Counsel wrote the letter before action, and KFW therefore is to be inferred as giving instructions because they're General Counsel. L30 probably don't have any. I think it's insolvent, so L30 doesn't have anything of its own, does it? It's got the two people who attended the board minutes meeting. There's going to be presumably cross-examination of those and of the General Counsel of KFW, and all that will reveal what it reveals, and then there'll be maybe an argument instructions about? I mean, why does giving instructions make a blind bit of difference to anybody? Anything?
Well, my lord, I think all I can say on that is that issue doesn't arise on the appeal because it's been accepted by my learned friend.
So what doesn't arise?
It doesn't arise on the appeal. It didn't arise before.
So what doesn't arise?
Whether ultimately this information would add to the to what Credit Suisse already know. Parties have been proceeding. The court below proceeded on the basis that it was relevant information, and indeed found it was information which Loreley 30 couldn't claim privilege over. So.
Is not an issue.
Well, it isn't
so
an
that's
issue.
Saying you're saying back off, really.
Well, Mr. Justice Pickin made the order that the information should be provided. He made the order for the disclosure. If the claimants considered that wasn't an appropriate order, then they should have taken steps to appeal that order. It's in a sense we're too far down the road now.
Well, Mr. Oppenheimer, I was going to say you're in my court now.
It's also right to note that both those orders were expressly subject to taking the privilege objection.
Mr. Justice Pickin's order. Yes. Yeah. Anyway, you say Mr. Justice Pickin's order was made, it's not appealed. That's correct.
I'm not sure there's more that I can helpfully say, other than just on the background, to deal with my lord's point that it's very curious that this has all come about effectively as an interrogatory. That's not quite right, and I'm not sure whether that was picked up when you looked at the engagement letter and Hibbert too, because the basis for the redaction at paragraph 6.1 of the engagement letter is precisely the same basis that Loreley are relying on to claim privilege as a reason not to respond to the request.
Mr. Hibbert makes quite clear that when he claims privilege, he does so on the basis that Mr. Lord's submissions are correct.
That's right. That effectively, yes, he's saying 6.1. I'm relying on the proposition that you don't need to disclose the identity of those instructing the lawyer. That's the basis for the redaction numbered 6. I don't think there's any dispute about that. And in fact, when we dealt with the redactions below, I think Mr. Hobson, who was dealing with the redaction, said, well, redaction 6 is the same issue that we've spent the day discussing. So he didn't deal separately with redaction 6 because it was precisely the same issue.
The substantive issue is whether redaction 6 is allowable because it discloses the identity of the person instructing the lawyer.
Yeah.
That is the precise issue in this case. They're not identified.
It is. It arises on the RFI as well, but if my lord wants to see it as a point arising out of disclosure, then yes, that is another way of characterising it.
It also applies to redaction 1, doesn't it, on the previous page, page 236, because the same point is taken at 25.3 in respect of the board minutes.
My lady is absolutely right, yes. At 25.3 of Mr. Hibbert's statement, the redaction is made on the basis of litigation privilege because the redacted text reveals information concerning the identity.
So in other words, as the Master of the Rolls has observed, although the identity of 2 of the individuals who attended the meeting is unredacted, within the text there are redactions relating to identity.
Yeah. Mr. Sher reminds me, just because my lady's picked up that particular bit of Mr. Hibbert's statement, Reynold Porter Chamberlain did actually say that they'd made a mistake when they explained that redaction, and you'll find that at page 291 of the bundle. I think because they misnamed, is this correct? They misnamed in that paragraph when they said persons giving instructions to Loreley 30, I think that should have said to RPC. You see that at paragraph 1 of the letter.
Yeah, but that's just technical.
It was just in order that nobody was acting under
The
some
avoidance of
misapprehension. My lords, my ladies, is that a convenient place to stop, and I'll start properly with my submissions.
Okay, you've got 2 minutes if you want it.
I'll take my 2 minutes then, if I may, to make my 2 opening observations before I'll set out after this short adjournment my roadmap. And the 2 opening observations are these. First of all, it's very important to recall the very modest scope of this judgment. The judge did not find that the identity of those who are authorised to give instructions to lawyers can never be subject to litigation privilege. He accepted that there might be situations in which revealing that identity might involve disclosure of the content of a privileged communication. But he found that there was no evidence in this case put forward by Loreley to suggest that identification of those communicating with the lawyers would have such an effect. So that's the first opening observation. The second one is this. One of the points which was debated below, to which my learned friend referred, was the question of whether lawyer-client communications can be subject to legal advice privilege and litigation privilege. That issue does not arise on this appeal. The judge found in favour of Loreley on that point, and we have not issued a respondent's notice. So this appeal proceeds on the basis that both legal advice privilege and litigation privilege can apply to lawyer-client communications. And I only want to make this observation, particularly given how the matter is put in my learned friend's skeleton, that the issue was below a threshold point for Loreley. It is not any kind of threshold point for Credit Suisse. And we're content to argue the appeal should be dismissed without attempting to resurrect and re-argue that point.
Can I just ask you to think over the short adjournment about the formulation I put to Mr. Lord, that what the judge was really saying was that the identity of the communicator will only itself be privileged if there's evidence that disclosing that identity would disclose or give clues as to the content of the communication. And that's my distillation of what is about 20 paragraphs, which concludes at, I think, 51 of the judgment.
Well, I think, my lord, I'm already going to be addressing you on that, because I think actually what the judge was doing was something very orthodox, which was saying either you have a privileged communication or you have secondary evidence of a privileged communication. And there's a lot of law on that. The secondary evidence being a document which would otherwise disclose or give clues about a privileged communication. And it's, we say, very striking that my learned friends do not even mention that doctrine in their skeleton. They haven't mentioned it in any of their submissions this morning. And actually what the judge did here was very orthodox and in accordance with established principles of legal professional privilege.
Right. Okay, well, we'll resume at 2 o'clock.
All right.